How are we doing here physically and online? How are we?
Very well.
Very well? Okay. You're welcome to day 2 of the Baraza. We're excited to have you both physically and virtually. And to remind ourselves, for purposes of language justice, English is channel 1, Spanish speak slowly, do not use jargons, and also make sure that we are all walking the journey together. We are here for day 2, and we're here for day 2 to continue reimagining a regional Afrocentric approach to litigating reproductive justice through South-to-South knowledge exchange. And today, we're going to have our keynote address. Can we have some ululations? We're having our keynote address today, and we're going to have a response. But also today is going to be a day where we're going to have deeper discussions within ourselves, as well as starting to think through, after we've had it all, how do we move ahead? In terms of our program, remember we agreed yesterday, today is going to be slightly longer, so we beg your indulgence to walk the journey with us, because it is a process, but also it is 1 in a million chances that we get issues that are dear to our hearts, but even also to jointly plan and strategize moving forward. So now, between now and 10:30, we are going to have the keynote address and the response to the keynote address. And then after that, we're going to continue our own internal discussions where we are proceeding as the team that is here, and we'll say bye-bye nicely to our online audience, because there we're going to get into the kitchen to start cooking and making sure we share with them the final meal when it is ready. So our online participants, if you have any comments for the keynote address, you please type those in the chat, and then we'll pick them up and they'll be responded to. So with that, I'd like to invite the panel that is going to discuss with us the keynote. I'll first of all invite Giovanna Rios. Giovanna is the Executive Director of Women's Link, an intersectional feminist and anti-racist, anti-ableist, and anti-colonial human rights organization. At Women's Link, we believe that they succeed in unleashing the power of women. They believe in power as an axis to change and the work that we do. They fight for gender diverse people to ensure that they access justice, as well as ensuring that there is feminist partnership litigation. Giovanna, you're welcome. Then the next responder to the keynote comes in from Kenya, Isabella Mwangi. Isabella is a lawyer with 8 years experience in human rights sector, and specifically working with women and children's rights. With women, sexual and gender-based violence. She is part of the Legal Support Network of Kenya, and she has written as well as published extensively. She was recently appointed as the Chief Justice by the Chief Justice to serve on the National Council of Administrative Justice Committee in Kenya, as well as she works a lot with the Police Care Committee of the National Police Service. Isabella, you are welcome. So prepare, oil your hands and prepare. Have you oiled your hands? Oil them. I can't hear them being oiled. Oiling, I want to hear the oil. Okay, it's with great humility and honor that I present to you our chief guest. Our chief guest is none other than Anand Grover. Anand is the director of the Lawyers Collective in India and is a senior advocate practicing in the Supreme Court of India. He served as the United Nations Special Rapporteur on the Right to Health from August 2008 to July 2014. He has 42 years' experience in strategic litigation, challenging colonial laws and barriers to health rights of marginalized groups. Anand also brings knowledge, valuable knowledge and expertise on the how to do that we would like to learn from in this Baraza. And as participants, physically and virtually, we are honored to learn a lot around legal activism, as well as strategies of promoting reproductive justice, addressing challenges that are faced by historically marginalized communities in Africa. You are welcome, Anand, and we are happy finally you are here, and the airlines have not connived against us. Welcome, Anand.
Thank you.
So I'll not take so much of your time. I'll invite Anand to come and give us the keynote address on South to South learning as a tool for advancing reproductive justice through strategic litigation. Anand, you are welcome.
Should I do anything? Thank you very much. Indeed, it's a great pleasure and honor for me to be here. In fact, I don't think I'm going to teach anybody anything. I'm going to learn a lot. Because when I got this email from my very old friend, he's very young, I'm not that young, Moses. When I asked him his age, I was shocked that he's so young. Anyway, so maybe I'm actually getting older, Moses, I don't know. But anyway, I have known him for a very, very long time, and I'm so happy that Haki is doing so well. I was so happy to learn that the message, and actually I must say, if I may, if I have a bit of time, with the permission of the chair, that you actually evolved a new concept of working as civil society. Because I'm a litigation activist on the road demonstrating, and I've had my share of attacks by our government. But I am really, really thankful to my old friend, Moses Mulumba, and I'm very happy to see that that you actually attracted so many people from the developing world, if I may put it. But the topic of today's, and I'm very, very thankful to Sharon, who's been negotiating my travels by Kenyan Airlines from Mumbai to Entebbe, because I wasted a whole night and a day. And that's why I slept very well. And I was wondering whether I'll be able to actually wake up. So today's topic, actually, and I was just on this issue that, am I supposed to change the slide or? Oh yeah, okay. I don't know. Oops. Okay. You know, when I got this invitation, I got a very interesting write-up. What is colonialism what is colonization and what is colonialization. I think that's a very important distinction. And I'm going to start with that and actually try to evolve in that. And what the remit of today's meeting is, and maybe the conference. Colonialism is actually the imposition of power by people from the West in most countries, Latin America, Africa, Asia. And after independence, the formal independence, the remnants of the colonial culture remains, and that's what's coloniality. And it remains in different things. The ideologies, the literature, and very importantly, in law. And at the outside, I must say that it evoked my thinking again. And as a UN Special Rapporteur, I was from 2008 and 2014. My main aim, and at that time, I must say, I did not understand coloniality in the way it's been put today by academics. And I must say, superb note, high quality, and I was so happy. But the most important aspect of coloniality is criminalization of behaviors. Whether you take abortion, whether you take sex work, whether you take same-sex relation. I'm very mindful that I'm in Uganda, which has delivered a verdict against my colleagues in the same-sex community. It is criminalizing of behaviors. Prior to that, and even in Europe, it's not a European thing that criminalization actually was with the advent of a particular culture, Roman Catholic, in Europe. So I think that's very, very important to understand. And I'll denote that, and actually criminalize of abortion is coloniality. So if you want to change, you have to completely get rid of criminalization of abortion. That'll be our aim. I think we are getting there, but it's going to take a long time. So what was, most of our countries, I'm sorry to my friends from Latin America, hablo español un poquito, sorry. But unfortunately, we are in Uganda, and I'm from Kenya, not India. I was born in Kenya, lived in England. Namnagani. Okay. So I still remember my walk to my school in Racecourse in Nairobi. So I still contribute to that school. Anyway, the point is that a lot of us have been influenced in the common law countries. The British rule. Common law is basically judge-made law, not statutory. So in that conception, it was also influenced later on by Catholicism. But common law conception was very different from what we see today. But as I said, in Europe, the Greeks and the Romans originally, before imposition of Christianity, they did not actually have the same notions. It was different. And they did not consider the fetus in the way Roman Catholics do. They were not really concerned with the abortion in that sense, or protecting the unborn. They didn't have a legal conception like common law has. But as I said, earlier belief of philosophers was that a fetus did not become formed and begin to live at least 40 days after conception for a male, and around 80 days. So one of the most important features of abortion law is to either recognize that the fetus is viable or it is not. And let's be put at the outset. In Roman Catholicism, or Catholicism as such, moment an unborn child is conceived, that is a person in law. And therefore, you cannot do anything to damage its probable viability. It's not viable at conception. And technically, viability comes in common law. And this is very, very important to understand. Viability actually was Can I just take this out? Yeah, thanks. Viability was understood in common law when a woman is quick with a child, meaning thereby that the woman has the child, the child is moving in the womb. So that is known as quickening of the child. The woman is supposed to be quick with the child. And that, according to common law, indicated that the child is alive and kicking literally in the womb, and it would be viable. So after the woman becomes quick with the child, then you cannot abort. That is the old common law conception. It changed. That changed because of the influence of Catholicism, etc. So, and one of the most important judgments, and you'll see this, of the English common law is R versus Bone. And this was a case where a surgeon carried out an abortion on a 14-year-old girl, obviously a victim of rape. And he did it pro bono. I wonder, because he did it pro bono, the jury was influenced. And remember, there's a jury trial. I don't know, people from Latin America, are you aware of the jury trials? So it's not a judge. Today in India, there are no jury trials. I don't know about Uganda. Are there jury trials here? No. It's only the judge who she or he decides. I can't say in Uganda transgender men, transgender women, right? They don't decide. But there are actual so-called citizenry who decide the questions of fact and law. So in R versus Bone, it was a jury trial, and the issue was whether a surgeon carrying out an abortion to save that child's life would be protect against criminality. So he was charged with under the Persons Act of unlawfully procuring abortion of a girl, which was a crime. And this is the most important thing. If I, as a woman, have a child and I want to abort, should it be my decision or somebody else's decision? Should it be the surgeon's decision or should it be the state? Ideally, if we believe that it is my right over my body, it should be entirely my decision. But the law never saw it like that because it was so heavily influenced by Catholicism. And that's not only European in the sense, because before Catholicism actually reigned Europe, as I said, in Greece and Rome, it wasn't the case. So, if she only has the right to decide, then she should be able to decide either way. But over a period of time, they evolved exceptions to that in the sense that the state could decide. And the state originally decided in Europe at first in the Roman Catholicist era, then there were exceptions carved. Allow the woman or the girl child to abort if it was necessary to save her life. And in this case, he was acquitted. This is the first case in England. And because we were ruled by the British for a long time, we were influenced by that. So this is a very important case. And this had a lasting impact in the Commonwealth, that is British ruled, and as also in the US. Now, it was then actually taken into the penal codes. So the penal code in India, the Indian penal code, was the basic model penal code all over the British Commonwealth. Now, for example, so-called homosexual sex. I don't know what's the difference between homosexual sex and heterosexual sex actually, but there's this notion, homosexual sex. Because let me tell you, and I've been doing that work for a very long time, from 1997 to the date we won in 2017. So long battle to get rid of criminalization of same-sex relations. But actually 377 of the Indian Penal Code is replicated everywhere, 377 everywhere. And it actually did not only address homosexuals, it was the sexual act, which was supposed to be unnatural. Because remember, the British, and this is very interesting, the British or the Europeans in the old days thought sex should not be for pleasure. Were they right? They were right. They said sex is only for getting children. It's a sin. I'm glad you're laughing. They never enjoyed sex. I think that was the problem in the Catholic mold in the old days. So, indeed, if you had sex for pleasure, and sex could be had for pleasure not only penile vaginally, penile oral, penile anal. And I remember, but a lot of heterosexuals actually engage in penile anal sex. And people didn't believe that. I said, please go to look at any porn site. And I said, how can you think like that, porn site? I said, all the children are looking at porn sites. And if you adults don't, you won't know how to address their issues. But anyway, so this was the notion. And this Catholicism actually ruled, or Christianity or religious puritanical rule was such that not only it influenced sexual relations, but also abortion. And also, in the case of abortion, women were second-class citizens all over the world, except very few places. The example being Kerala in India, the southern state, where actually it was a matriarchal and matrilineal society. And some native communities in Latin America, North America, they were also matriarchal and matrilineal, very few. Generally, all over the world, they were patriarchal societies and patrilineal societies. And actually, colonization heavily influenced that. So, in fact, abortion meant the woman, who was actually not even a second-class citizen before the 20th century, she couldn't decide at all. She had no role to play in her own life. Remember, the suffragette movement, the actual right of women only came in the 20th century. So, the Indian Penal Code actually absorbed that thinking, that you cannot, and Indian Penal Code was a model for the rest of the British Commonwealth. So, I'm not going to go into detail because that's not necessary. But causing miscarriage was actually an offense, and if it was after quickening of the child, then it was even worse. Now, this is my main point. Criminalization of abortion, and in my reports as the UN Special Rapporteur, I actually concentrated only on criminalization. But let me be honest, not because I thought of coloniality. I was unaware of it until actually recently, and this note reaffirmed it. But in society, whether it's drug use, okay, I'm going to ask you a very, very asked this question at the National Judicial Academy in India. All High Court judges and Supreme Court judges were sitting. And I asked them a question, which I am going to ask you. How many of you take drugs? Liars, I drink alcohol every day. What are you people? You're not only lawyers. You see, by the way, my classes in Georgetown and Chicago are like this. They're fun, and I make people think. Alcohol is a drug, for heaven's sake. So is marijuana. It's better. Marijuana is better, by the way. It's a great appetizer. You know, why did the Americans impose criminality? Because of Catholicism. Why did they take it out? Because of science and pleasure. Let's be very honest. When I was a student at Surrey University in England, every evening after drinking and dancing and all that, and for reasons which I won't take, and even if I had a very heavy dinner like last night, I would still be feeling hungry. Why? Because cannabis actually is a great appetizer. And now we know, in the US it's sold as medicine for so many things. And we lost sight of that when it was criminalized, when Nixon had the war on drugs. So criminalization by the West because of colonization, because of coloniality, is the biggest problem that faces us today. Whether it is homosexuality, whether it is sex work, whether it's abortion or drug use. Criminality. So in fact, in my tenure as the UN Special Rapporteur, I concentrated on criminalization. That had to be removed. So what is the problem about criminalization of abortion? It is not evidence-based. It generates, when you criminalize somebody, Like everybody said, I don't take drugs. Why do you say that? Everybody sat quiet because it is stigmatic. But when I became a lawyer, I had to stop. Very simple. I couldn't afford to be smoking in the night and get caught by the police. But I had I must tell you, I had a very, very nasty experience. I teach at Georgetown Law Center in Washington. And, I used to stay opposite Georgetown Law Center, near Union Station. Good hotel, gym, etc. But then all my younger colleagues told me, why do you have to go to these hotels? Go to Airbnb. So I said, okay, you book a hotel, Washington. I went to this Airbnb, 20 miles from my place. No gym. I had to run on the pavement, etc. Anyway, to cut the long story short, that I went there on Friday night. On Sunday, I left, and there was a raid of the Narcotics Control Bureau, whatever it's called. If I had been caught, I would have been in jail. Airbnb. I stopped going to Airbnb. No, problem is criminalization. Recreation use, sexual pleasure. Just imagine, it's the pleasures that colonizations hit. Africans, Asians, and Latin Americans were having a lot of pleasure. Sex, dope, everything. The Brits didn't like it. Stop it. So it is, first of all, it's not evidence-based. There's no basis for it. It actually generates stigma. Then it doesn't make, because stigma, criminalization, you can't get healthcare goods. It does not allow a person who's criminalized, a woman who has to face criminality because of abortion, she can't take decisions for herself. She can't even take decisions in society. It disempowers women. And not only that, I was in Poland and the issue was abortion. You know what I faced? Vigilantes standing outside hospitals in respect of a woman who wanted to have a legal abortion. People are standing there, including men and women. There were no transgender people then, by the way, in Poland. There were, but they were not visible. Anyway, they were vigilantes who were saying, you can't have an abortion. That kind of stigma. So, this is the problem, that you have stigma, and then because of that, like just now, I said, how many people take drugs? People don't respond. There's no information exchange, no debate. I use this anecdote. Most of it, and most important, criminalization actually interferes and impedes with a woman's dignity, autonomy, reproductive choices, by not allowing them decision-making powers at all. Ultimately, it has poor health outcomes. Wherever abortion is criminalized, women's health outcomes are bad. And then most importantly again, women are actually put into jails. What is the purpose of sending a woman to jail if she's had an abortion? Can you, it's ludicrous and mad. So, because of that, I don't know, how many of you, I'm going to ask another. How many of you have been to jail? I'm not talking as prisoners, please. Are you see? Times. Yeah, you're a lawyer, not a liar, right? Okay, that's another one. So going to jail, you have to see it. I was actually caught in a demonstration actually, and this is long time ago. Don't think about my age now. 1968. I was a student. I was the deputy president of my students' union at Surrey University, reading, you won't believe it, biochemistry. So I was demonstrating against the US on Vietnam, and I was caught. And they put me in the clink. I was there for a whole night, and I know how bad it is. Ultimately, I was released. Demonstrate against the Americans, that's the place for you to be. It's not a nice place. And I was there only for one night. Now I do cases for people who are accused of being Naxalites or Maoists in India. I'm doing 5 of those cases. and they have been in jail for 5 years without trial. It's not a nice place. And for nothing. You know, the states, when they get power, they misuse it. Anybody who gets power, unless there is accountability in law, in fact, my learned judges will tell me, sitting here, if there is no accountability, their powers are misused. Even if law to have accountability and to be in jail for being a victim, I would say a victim of abortion as a woman is not only stupid, it's harrowing for that woman. Not a nice place. So, according to me, coloniality brought abortion as a crime. That's what has to go. That should be our agenda. If we get rid of abortion as a crime, we'll make huge progress. And we are making. So, as I did in 2008 to 2014 as the special rapporteur, the agenda even today, in India we have achieved it quite a lot. Decriminalization is the need of the hour. So I think that should be our agenda, not only because it's the best thing to do, it actually restores autonomy, dignity, respect, reproductive choices to the woman, but also it actually makes them into full citizens. Now, see, so what did we do in India? I'll give an example of India. I mean, it would be still silly of me to talk about Kenya and Uganda when better people are sitting here, or from Panama. So we actually replaced the Indian Penal Code. The Indian Penal Code. Oh, I must tell you, this is an anecdote. The Indian government, the Modi government, thinks that it's the new phase of Indian civilization. So they have changed the law. Indian Penal Code is called something else now in Sanskrit. Of course, they haven't changed it. They made it more criminal and they call it decolonization. So I'm going to write a piece that is actually more coloniality now. So anyway, in terms of the law, we came out with the Medical Termination of Pregnancy Act. So we use the concept of how the unborn child actually becomes viable, which is based not on a religious notion, but it's based on medical evidence. So, and it's not foolproof, you know. In every person, in every woman, the child may develop differently. So, the basic regime is that up to 20 weeks, this is a statutory law, Medical Termination of Pregnancy Act. Up to 20 weeks, it has to be done on the opinion of one registered medical practitioner. Between 20 and 24, on the basis of opinion of two medical practitioners. Beyond 24 weeks, it is actually done by a constitutional court. So in India, we have at the top the Supreme Court. In each state, there is the High Court. Like in the United States, there are Supreme Courts. We have High Courts. They are constitutional courts, and you can't go to the trial court, as it were. You have to go to the High Court or the Supreme Court to get an abortion done after 24 weeks. So a few cases on that. This is very important case, and an old case, 2009, where the woman was actually mentally ill. She was an orphan, she was in a mental health institution. After the discovery of her pregnancy, the administration, who doesn't think that the woman has any rights, she has no agency, they said, oh, she's mentally ill, she can't take care of her children, let's get the abortion done. No consent by the woman. That is the attitude of all states. Let me tell you, recently in HIV, you know, India produces a lot of HIV drugs. By the way, Uganda has one pharmaceutical company here, which is associated with Cipla. So I'd gone to their site last time. But in HIV, we had drug stockouts. So I represent the people living with HIV. We don't say people living with the disease. People living with HIV is a positive connotation. The language also has changed. So we talked to the government and said, look, we should have this sorted out. They said, no, we know best. You don't know. And then they actually occupied the National AIDS Control Organization office at the time when the HIV conference was going on in the rest of the world in 2022. They couldn't do anything because the whole thing was being televised and international. They couldn't do anything. Of course, then they actually started targeting me and some of the leaders. But anyway, I advised them they should withdraw because they started getting the drugs. But you know, the notion is, what do HIV people know about HIV? We know best. Same thing happened with TB. TB people need not come on the discussion table. So anyway, we forced them to have a discussion, and the case came up recently. And I told the judges, I said, unless the people who are affected can take part in the decision making, you will never get a proper decision. You know, I always tell my young persons, from people who are not educated, you know, people who haven't gone to high school, they don't know about law. How do you explain them that participation is the most important and the best way to come out with the best result? I always tell them, my friend here can only see my left side. She can't see my right side. But if you want to know me properly, you have to consult her. Sorry, you're a magistrate and you have got an award yesterday, I know. Sorry to. So if you want to know me fully, holistically, you have to consult. These two have to consult. That's the elementary way of saying that if you want to comprehend reality, all participants have to be consulted. Participation in decision making by all stakeholders is the most best result. So when we were drafting, the Lawyers Collective drafted the HIV law, which became an act, we had huge consultations from every stakeholder, positive people, children, every group. But the Chandigarh administration thought, she is mentally retarded. What does she know about abortion? We should abort. The High Court agreed with. Can you believe it? Because they don't think. For them. I'll give you another example. I went to Japan as the UN investigating the Fukushima disaster. You know the Fukushima nuclear disaster. So as an alternative, the Japanese, to the disaster, the buildings had been destroyed, homes had to be built. So even for physically handicapped, they had to build homes. But did you think they consulted them? No! It wasn't necessary. We know the best. We are from Harvard, Oxford, not Mumbai, sorry. And we know best. So they didn't consult. They made the homes which were completely unfit for those people. And Japan, which is highly developed. So when I went there, I made a report on a number of things, and they didn't like it. I'm a very critical person of myself and other people. That's my job as a rapporteur. I can't avoid that. But you have to do it in a friendly manner. You have to do it on evidence. They didn't like it. It was the only report where every sentence was actually rebutted. Every sentence. But the UN Human Rights Council said, no, you have evidence. Therefore, we accept the report. They had to take the humble pie. And I'll tell you another example. Sex workers in India who I work with, some of them have taught me a lot of things. I won't tell you what. Sex workers have taught me a lot. One of the cases was amendment of the law. And I thought it was good for them, honestly, as a lawyer. So they said, Anand, sorry, like you tell everybody, we should know what is good for us. You can't decide. I said, fair enough, you are right. We went to the government, and the government, Anand, why are you bringing these sex workers here? I said, it's affecting them. They must be consulted. They said, okay, now this is you are talking in English and Hindi and all that. You go back to your office and explain it to us. They said this, when we went to our office, they said this law accepted. Even I, who is so glued into rights of people who are marginalized, can make a mistake. Please never think you remit, it's arrogance. So I had to eat the humble pie. And I always tell them, through example, please consult everybody, even children if they are affected. So participation is very important. But the High Court said she is mentally ill, she need not be consulted. Fortunately, the Supreme Court said nothing doing. You can't do all that. And they actually said that she is mentally retarded. She can actually bear a baby. This is, of course, not abortion. It's the other way around. And she can, in fact, decide for herself. But the governments must support her through this. So that actually became a very, very important decision because it talked about the right to reproductive autonomy and personal liberty. But it's the other way around, remember that. But it goes also for deciding for abortion. But the law says now that a person who is carrying a child, unborn fetus, she has to decide first. You can't substitute her decision. And then, please look at that. Reproductive choices, her bodily integrity, privacy, dignity. I'll come to that later. But so they actually established for the first time that a woman at the Supreme Court level can. Then this is another, there are 4 very important cases. I'm not going to go through detail. But this is the second case. This is recently, there are 3 recent cases which are very important decided by the Supreme Court. So this is an unmarried woman, 25 years of age, having a consensual relationship, became pregnant, but her partner said, sorry, I'm not going to marry you. So she obviously did not want to carry on with the pregnancy because being a pregnant woman and having a child unmarried is still friends of mine who have had children without marriage, but that's only certain section of society where it's tolerated. For ordinary people, it can't be done. The Delhi High Court, which is the state court, they said, no, you can't do this. You can't have an abortion. That's a constitutional court in every state. The Supreme Court said nothing doing, it's her right. And if she's within a particular period of time, she has a right. So it's not an exception like the Rex versus Bone. They said the medical, so 20 weeks, 1 registered medical practitioner, 24 weeks, 2 registered, and beyond that, a medical board has to be set up. Okay? So they said the All India Medical Institute in Delhi will take a call whether the abortion can be done without harm to the woman. And that's what happened. And there's another one. This is the husband and in the previous case, the woman herself was deciding, her partner didn't want. And she actually wanted this case, she wanted to decide to terminate the pregnancy, unable to do it because under the Act and the rules, it was beyond the period of limitation. And she said that she will actually, was the only member. So the Supreme Court actually allowed the termination of pregnancy on the ground, please note, that continuing with the pregnancy could seriously imperil her mental health. Then actually it became another problem because later on the All India Medical Institute decided that in fact there is strong chance of survival of the child or the unborn child. And the question was because the unborn child heartbeat had started. So the All India Medical Institute decided to approach the court and said, should we stop the heartbeat of the child? So they said, no, you can't do that. There are no abnormalities of the fetus and the reports did not suggest. If they actually allowed the pregnancy to term, there would be a viable fetus. So it was a very difficult decision. So they said, no, we will not issue that direction. So she was not allowed to abort. So these are very, very sensitive cases. You have to take the decision not based on a religious conception. In no cases will the unviable fetus be terminated. That's not the issue. It depends on various constraints. What are the key elements? the woman has a right to dignity, privacy, bodily autonomy, reproductive choices. So in every case, consent of the woman has to be taken. It can't be substituted by the husband or the partner's consent. So, and there's another thing, which I'll come to in a minute. It's how you see the law. Do we see the law as static, serving society? Do we see the law as only a law in making? And as society transforms, the law also has to be transforming, not itself, but also help to transform society. In other words, is the constitution or the law transformative in trying to have an egalitarian society? Equality. And wants to be egalitarian. That's the stated goal, not that they actually want it in terms of their political ideology. And you have to keep changing things. Unlike the US Supreme Court in the Dobbs decision, which I'll come to in a minute, they don't see the US Constitution as transformative. A constitution can either continue to have an unequal society or it can be transformative. In India, we see the constitution to transform society. We were the most, until today, we are one of the most unequal societies. We had a caste system, it's still prevailing. You know what caste system means? It means people are not only divided on racial lines, but they belong to a particular sect of people. And it is actually tied to the occupation, like a sweeper, gardener, etc. And the people who are on the top, there were 4 castes, they don't even touch that person. And we had to change that. It was a very difficult period for us, but the constitution is based on transforming that society. So we have affirmative reservation within the constitution. So we have scheduled castes and scheduled tribes being able to occupy seats in all vistas of government. Like for example, if the merit seat would be at 80%, a person belonging to the scheduled caste less marks. Now, because the US unfortunately leads in these things either badly or in a good direction. In very famous case of Roe versus Wade, the US Supreme Court for the first time decided that there should be abortion based on sensible grounds. Prior to that, you couldn't get abortion unless there was, literally very, very difficult conditions to satisfy, like Rex versus Bone was dealing with. So in Roe versus Wade, there was a Texan law. You could only get abortion if it was to save the life of the woman. That's what they decided in Roe versus Wade. And they actually came out with the trimester protocol, that in the first 2 trimesters, the fetus is not viable if it is born. In the 3rd trimester, the woman, actually if it gives birth, the unborn fetus would be viable. And it based itself on the decision of the right to privacy. The privacy right includes intimate and personal decisions affecting child rearing, marriage, procreation, and contraception. And the state could only intervene on the basis of what is known as compelling state interest. So in the first 2 trimesters, the unborn fetus is not viable. The state has no interest. The state has an interest. Now, this was actually carried forward in the Casey versus Planned Parenthood case, but they actually didn't agree with the trimester. This was overruled. For want of time, I can't go into detail, but I'll dwell a minute on Dobbs, the last decision. Basically, the Dobbs decision came out with a completely, let me tell you, I spoke of this in the Northwestern University, I would say a dishonest decision. It's very difficult for me to say this with judges sitting here. Why do I say that? I said this in Northwestern and people attacked me. But I have to be honest to myself. Because those same judges agreed with Roe versus Wade when they went on the bench. It's sad, Unfortunately, the politicization of the judiciary has become a norm all over the world. We have that major problem in India now. But anyway, first they said, after 15 weeks, there is no question. And very importantly, the notion is there in the US that the US Constitution spells out whatever it is in the Constitution in the written word. It's not transformative into the Constitution. But that has enormous implications because everything has been read into the US Constitution, privacy, etc., etc. It's not explicitly stated. Even in our Constitution is the same thing. So basically, they said the US Constitution doesn't provide for abortion. It's not deeply rooted in our culture. That's one of the facets of the US decision-making process. If it's not part of your culture and tradition, then you can't actually posit that as an argument. So the real question is whether the Constitution is transformative or it is not. And the majority in Dobbs said it is not transformative. We've already known what we want to do at the time of the writing of the Constitution. Forgetting the fact that anyway the US Constitution is a series of amendments. Not only that, they were not honest in talking about common law. They just said common law, which is latter common law after Rex versus Bone, etc. Now, the text is not amenable to interpretation according to the majority. Even changing circumstances, you can't change it. Now, I want to posit this qua hour. How much time? I'm an Indian, so I can just go on and on. How much time? 5 minutes, 10 minutes? My God, okay. I'll give you an example of the Indian Constitution, which is transformative. A person's liberty cannot be deprived except by procedure established by law. That's very standard. US, India, all constitutions, unless there is a law to deprive a person of liberty or life, it cannot be deprived. That's a negative injunction on the state. In that Article 21 prescription, what did we do? We said, what is this based on? It's based actually on a US decision, Moon versus Illinois, where they talked of dignity. Now, dignity actually has a lot of facets. If I call somebody, oh, you're stupid, just that can be undignified. Or calling somebody in a racist slur can be undignified. Dignity has a huge potential. How do you live with dignity? It started on in a very famous case of Francis Coralie Moulin, where an Irish prisoner in Delhi jail wanted books for reading. And the jail said, like all jailers said, oh, no, you're not entitled to all this. Don't be a leftist here. That kind of attitude. So they said, no. The Supreme Court said, no. Even a prisoner is entitled to dignity. If a prisoner, she crosses the prison walls, her dignity is not impaired. She is still to be treated with dignity. Of course, that prisoner cannot walk out of the jail because she is a prisoner. But otherwise, all facets of dignity must remain intact. Therefore, she is entitled to books in jail. And on that basis, they said they develop the right to environment, the right to health, etc., etc., etc. Because dignity is the underlying basis of a civilized human existence. That's very, very important. So 5 minutes is an embargo. So just, for my Latin American friends, Mexican Supreme Court has also given a decision. I won't go into that detail. No blanket rights. I'm not going to read this out, but I'll just tell you that I did a written amicus brief in the Colombian court, which also upheld. Now I'm doing for Ecuador. In South Africa, we have the Choice of Termination of Pregnancy Act, which is very important. It's a good example for decolonialization, as it were. It gives the right, based on the obligations of the state to provide reproductive health, safe abortion. Right of choice is exercised by the woman. So agency is given to the woman. She has to choose. She has the right to be informed. She has the right to have access to the services. Now, the decolonialization note actually made these 4 points. I think they're brilliant, but they need to be discussed and interrogated. Don't accept anything that anybody says, especially me, without rancor. So, please be critical of any point. It's very important to be critical. Without that, you cannot move forward. Recognition. This is from the note, Moses, that you sent me, or Sharon. Recognition dimension to combat stigma, stereotyping, prejudice, violence, to recognize the dignity of a woman. This is the most fundamental. When the woman has to be treated with dignity in the context of abortion, if you have to allow her dignity, then everything must rest with her. Choice, consent, everything. Then, even in laws that are being made, they have to be participatory. Without participation, without proper consultation, you can't have a law. I'm giving the slides to everybody. Yeah? It's public property. I don't believe in intellectual property rights. If you know my work on access to medicine, I think it's wrong to have intellectual property rights. I'm very critical. Accommodation and distribution. These are the things. Now, last point I want to make, which is again controversial. So, one of the questions that were posited is human rights the best way to move forward? And they had a caveat on that look, human rights actually destroyed communitarian or community property in Africa, Latin America, Asia. Well, partly true, partly not true, but there's essence in that, because community property was only in India, for example, it's in certain sections which were not invaded by capitalism. Moment you had capitalism, community of property was destroyed. It's not to do with the West, it's to do with capitalism as it develops. So that's one. But human rights is a way forward. Of course it's a way forward. Of course it was set by the West. The Universal Declaration of Human Rights was set by the West. By the way, there's an error in the note which I must point out, that out of the Universal Declaration of Human Rights actually spawned the International Covenant on Civil and Political Rights. If you see, and later on, the International Covenant on Economic, Social and Cultural Rights. Now, actually, they are babies of the UDHR. If you read the UDHR, you can actually take chunks of it, plant it on the Covenant on Civil and Political Rights and the Covenant on Economic, Social and Cultural Rights. The basic difference was they were motivated, the civil and political rights, by the West, so-called capitalist countries, and the Russians, who actually moved the economic, social and cultural rights, because they were socialist. Actually, there's nothing to do. It's not that. It's just the political configuration at that time. The other important difference is that civil and political rights are supposed to be enforceable immediately. But economic, social, cultural rights are not immediately enforceable. There's a lot of debate about that also. But the aspect of discrimination, it is universally accepted. It is enforceable immediately. You can't deliver health services in a discriminatory manner. It has to be equitably. But if you talk of human rights, you can't be in a secluded, isolated space of abortion or sex work or drug use. You have to see the universe as a whole. And today, and what I'm about to say, I've been attacked by professors in Georgetown. But I welcome my attacks on me, actually. It's brilliant because it allows me to debate. Okay, so international human rights system, this is what I said in Georgetown, is under huge attack. Why do I say that? Israel is committing. Now I have to be very careful of the word because I'll be criminalized, if I may say so, for this. The International Court of Justice has held that there is a plausible case of Israel having committed genocide. Not one decision, 3 decisions now. First one, which was argued by my very close friend from South Africa, Adila Hashim. She was the lead counsel. And they held there's a plausible case of genocide. You have to understand the way rights framework works all over the world is that certain people are entitled to rights, though the formal rights are for everybody. Rights actually are realized only for some. This is very important to understand. In the US, Native Americans didn't have rights to citizenship. Afro-Americans didn't have equal rights. In the whole of Latin America, for a long time, Native Americans had no rights. And I don't know, my friends from Latin America, I studied Bartholomew de las Casas. You know Bartholomew de las Casas? He was one of the Portuguese. So I must tell you this, and I'll end with that. He was a Christian priest in Brazil, from Portugal. Unlike the conquistadores from Spain and Portugal were not learned people. They were what we call, people who are just fighters. They were sent to occupy and take over the Americas. And they did. It's a sad story. But Bartholomew de las Casas actually was a person who believed in some sort of human rights. But what was his position in terms of understanding Native Americans? So the conquistadores said they are not human beings, so we can treat them the way we are treating them, killing them, etc., etc. He said, no, they are human beings, but they are incipient human beings, like babies. They still have to learn. That's the story of colonization. Today we are in a different world, but colonialization persists in our minds. I'm lucky, I was born in Kenya, didn't go to India, so I have no caste issues. I was in England, so I was living in an egalitarian society to some extent. Racism was there, but I fought against it. I was the deputy president of my union, and I was lucky to be able to lead even an occupation of the university. But the vice chancellor congratulated me for that afterwards. The point is, we have to use our knowledge to be able to fight for people who need our help. As a lawyer, it's a great pleasure for me to always fight for the underdogs, whether they are marginalized communities, women, native communities. Big issue in India also. There are huge areas where forests are being taken over by mining companies. So I am there to fight for them, and I hope you are there also. And I hope you will actually go back to your respective countries and make sure that criminalization of abortion is actually outlawed. Thank you very much.
Thank you very much, Anand, for challenging us. I hope our colleagues that are online, the land friends you've had, we have to use our knowledge to fight for the marginalized people. I know we are all hot with response. Keep your response. We're going to have 2 respondents, and then we're going to open up. The ones online is going to be through chat, so you can even start sending in your chats, and then us here, we're going to respond. With that, I'd like to take us to Latin America. We're going to invite Giovanna Rios from Women's Link Worldwide from Colombia. Giovanna tells me that they are practicing their English. So they're going to speak in English, not in Spanish. Thank you very much, Giovanna, and you're welcome to respond to the keynote address.
Thank you. Buenos días.
Buenos días.
Good morning. First, dear Anand, thank you for sharing your reflections and inspiring us today. I think it was, I think I can, like you are, can relate with our minds going to so many places, right? And trying to connect with all that you were saying. So thank you for generating that space to talk today. I also want to thank all the organizers for creating this space to have a cross-regional exchange of reflections, learnings, and unlearnings. And I want to thank especially to Haki, Voz Feminista, Sehur, and Rios for inviting Women's Links to participate in this Baraza. it is an honor to share my reactions and participate in our South space. I think thinking about what you share, and I think we all can relate and know very well colonialism and how colonialism in our countries and in our lives is been impacted, and how we experience that from our bodies. And I grew up in Panama, a country that was colonized several times because of our resources associated to the Panama Canal. So the Panama Canal has been a source of growth, yes, but also a source of pain. And my country was invaded by the US government in 1989. And such a horrible experience for my country and my family shaped me and ignited me. So that's why I'm so passionate about our anti-colonial values. So I would say by hearing you that our sources, and you talk about our role as people working in strategic litigation, but beyond as a human rights defenders. I think our sources of pain, joy, courage, rebellion, and liberation are a great strength for our South-South cooperation, and I would say for our South-South conspiracy. Because our fight for reproductive justice is a collective fight for freedom and liberation. And we know colonialism very well. The impacts that it has in our bodies and access to healthcare, including abortion. And you described several cases where we have seen the impact. And we understand how it's functioned. But most importantly, one thing that we can see through cases, but also through activism, advocacy, is that we know how to deconstruct it. We have that power, we know how to. Our anti-colonial values unite us, and it is important that we continue reclaiming our role and our power because we know best how to solve our own problems. And I would say that as a proud member of the Green Wave movement, one of the things that we keep on saying is that it is also time for the global North to learn from the global South. Thinking about the Dobbs decision, for instance. We also bring and share our solidarity, and this green bandana that you've been seeing through all this way is a powerful symbol for all of us. And I think the symbol is a symbol also of freedom because it goes beyond abortion. It is a reproductive justice cause. And in Colombia, for example, the Green Wave movement used freedom, the word freedom, libertad, as the main word for our fight for reproductive justice. So we see freedom and liberation connected to this Green Wave movement and the Causa Justa movement. So at Women's Link, we embrace the reproductive justice concept that has been defined by women of color in the US in 1994. And I know that Sister Son will be sharing some reflections. And I think I wanna also talk about and tackle on the power of our connection. So this year, for instance, Women's Link connected with the Sister Son friends and with Monica. And we've been learning more and exchanging information about the reproductive justice concept and what it means for Black women and women of color in the Global South. And we are doing those exchanges. This year, we also had an information sharing session on a specialized gender-based violence course in Kenya, led by the gender-based violence advisor to the Chief Justice and the Ministry of Justice in Colombia. And this is just to show and share with you how important it is that we continue exchanging information and learnings as a tool to decolonize. And I think this Baraza in itself is a way of saying how we are, deconstructing systems of oppression And we need to keep doing it more and more and see ourselves as partners in learning and unlearning. I also want to talk about what it means for our systems to be decolonized. And we have seen similarities, right, in different legal systems and mechanisms in the global South countries. And I think that offer us, in comparative law, an opportunity and a tool to continue expanding our efforts. For example, I want to bring an example of Latin America and a work that Women's Link has been doing with the Lenca and Tulupan indigenous communities in Honduras. So in the Inter-American court system, there was a request from the government of Chile and Colombia about a consultative opinion on the impact of the climate crisis in indigenous communities. And as you know, there is a process to submit an amicus. And the process in itself, brings up all the obstacles for people to participate, talking about participation that was brought up in the keynote's remarks. And one of the things that we did is to say to the court, yes, we will follow the procedure because otherwise, opinions wouldn't be included. But we also challenged the procedure and the mechanism. And we created with the Lenca and Tolupan indigenous people an oral amicus. And we share both, the written amicus and the oral amicus. Why? Because orality, it's been a key component of how indigenous people reclaim their own rights and how they fight for justice. And I think it's very important that when we look at strategic litigation and legal actions, we not only think about the content and the goal, but that we also think about the procedures and the mechanisms and how we challenge those. And I also want to say that in Kenya, my colleague Agnes Rogo from Women's Link, she leads our programs in the East Africa region. She also shared with me, and we've been talking about the example of the judicial system and how that's been upholding indigenous justice through the work with elders. So there is a lot that we can learn from each other as South-South country and think about our collaboration. Let me finish saying something that I think is very important in your last comment, and about how we use knowledge, how we use our privileged positions to be interacting with the law and with the systems. I think it's very important to say, and this is something we believe at Women's Link, that power is not in the law. Power is in the people, because we, the people, can use the law to oppress or to liberate. So as a feminist, I am very honored to work at Women's Link, because at Women's Link, we have made a conscious decision to use the law to liberate. Every day, we think about how we can use the law as a tool for liberation. And I'm very grateful that I'm here, to learn from you and from your organizations, because I know that we all share that commitment to use the law as a tool for liberation. Thank you.
Thank you, Giovanna. I'll now invite Isabella to come and respond from the point of Kenya and the African continent.
Is it still morning? Good morning.
Morning.
Good morning.
Good morning.
So as I've been called, my name is Isabella Mwangi, and I want to start by saying thank you very much for that informative session. And as I was listening to that, there's a very popular phrase right now in my country, I come from Kenya, that we are saying the fear is gone. Let's say it together. The fear is gone. Again?
The fear is gone.
And if you didn't feel that after you going through this presentation with Anand, then let me then be able to situate it properly for you. She has just said power is in the people, not in the law. And Article 1 of the Kenyan Constitution speaks of we, the people, are the ones who have sovereignty. And so it is time we start utilizing and unpacking what that sovereignty means for us. Allow me to be able to respond on two things, especially on the issue of decolonization, public participation, and finally end by talking about my call to action on how best we can then proceed. We are in this room because we all recognize that our laws are ghosts. They are ghosts, and it is a ghost that we must rid ourselves from. They're simply a ghost because of all the things that have been said since yesterday. They're exacerbating injustice. We are not being able to enjoy the equality in the law as it is prescribed. And this is not just being affected by women, as we usually are, the biggest victims, but even men are feeling it. And so it has created such a huge power imbalance. And this has been able to be seen in our laws on abortion, same-sex engagement, polygamy, land and ownership. And if we think about it critically, the British, who colonized both Kenya and Uganda, they came and the first thing they did was take our land, isn't it? Imagine how then they went on to redraft the laws on how we can be able to take back what was ours. Do you think they would have allowed us to do it? And so that is why to date we continue speaking of land laws that excluded half of the population, which is women. And so when we think about decolonization, and from a SRHR perspective, we must be able to think about the intersections. How are we being able to address all the intersections in the room? And I am happy to say that because of terms that have been used, terms such as barbaric, what were called barbaric because they came and saw women have a voice, men have a voice, and they could not understand. How do both of you have a voice? Who is the head, as the Bible says? But we all understood what we were doing, isn't it? But then that is a term now we often use when we look at people and we say, why are you dressed that way? Why are you dressed in your African attire? That is barbaric, isn't it? And so for us, it is good news as we sit in this room. It is good news to say that there is a shift that is happening in Africa. There's a shift that is happening in Kenya. So let me begin by talking about what is happening in Kenya. In 2010, we went back to the ballot box, and we have what we still call the new constitution, even if it was done in the year 2010. And for us, it is new because every time we read it, even as lawyers, we find something that is actually exciting and new. And we understand that these changes in SRHR will not happen in a vacuum. And so we must be able to understand what is the bigger context of what is happening that will allow us to then ride the wave of what is currently happening. So our new constitution was very big on being able to expand its protection on issues of equality and non-discrimination. And it further went on to talk about issues of reproductive health, especially in Article 43. And what that did to us is then we went on and did a specific law, which is the Health Act, and we now have a reproductive health bill. But I'm happy to state that it is no longer a generic bill. What we have done is we have taken into consideration in being able to understand that reproductive health is no longer a woman's issue. And so our current health bill is not only looking into issues about youth, because that has always been the focus. When we talk about reproductive health, a lot of programs that are going to be brought in Africa, they are going to start talking about, let's focus on the youth. But we forget that, as she told us the other day, she's a product of sex, meaning from birth, there are sexual reproductive issues we must take into consideration. When you're your youth, there are issues we must take into consideration. When in your 40s, when in your 60s, and when you're aging. Absolutely. So our reproductive health bill currently looks at that from that full circle angle. It's being cognizant that once you get to 60, because some of us, our parents are in their 60s, and we never like to imagine that they had to do what they need to do. And so it's always a very interesting conversation. But the fact of life is, it's a continuum. And so that is one of the greatest things that our bill has done. It has looked at the full circle of any man or woman's life. Secondly, our bill has taken into consideration men's reproductive issues. Yes, we are now cognizant that we no longer cannot ignore that to make a child requires a man. To enjoy sex, well, it might not always require a man. I retract. However, is this being streamed? However, we are very cognizant that even for men to be able to enjoy their sex in how best they enjoy it, they must also be healthy. Absolutely. So we are very cognizant that we need to start looking into men's health. Of course, as my colleagues have spoken yesterday, we now have guidelines that allow us to access safe abortion, that we continue to expand every day. We continue to expand and demonstrate why safe abortion is necessary. And one of the biggest grounds for us, other than the medical point, is being able to understand that we now are cognizant that if a pregnancy is occasioned by rape or defilement, those are very good grounds for being able to access abortion. We also are very cognizant that giving birth for women is no longer, we do not assume that it's an obvious thing. We are now cognizant that it could be a problem of either the man or the woman. And so we are now looking at assisted reproductive technology, how best that is working. But unfortunately, as you all know, there is a heavy pushback, which we have seen, and that's why the East African SRHR bill to date still remains a bill and not an act, because they are pushing back on how that is not African value for us as women, for you as men, to be able to seek technology to support in giving birth. Think about it. Then lastly, the bill has a whole section that talks about cancer, prostate cancer, breast cancer, and for women, there's the other third cancer, cervical cancer. And noting that cervical cancer is actually very high amongst African women. And the same way in the States, it's high amongst Black Americans. And so it's something that we needed to be very cognizant about. And even in line with state's obligation, this particular bill has actually said the state has an obligation to provide access to cancer treatment, noting how expensive it is. And so being able also to promote and create an awareness so that we are able to go for screening early. Beyond what is happening in Kenya, we must also be cognizant that there is a wave that is happening in Africa. We know what's happening in Mali. We know what's happening in Niger. Can we ride that wave? Can we? Can we start using what is currently taking place to think about how we can then, let's have the information now so that when the wave comes to Uganda, when the wave comes to Panama, Mexico, we have the information. We're not starting to think about it then, but we'll say we are ready. This is what it should look like in terms of being able to go through constitutional reforms, through parliament, litigation, and constitutional review, with the main goal of ensuring that our laws are contextualized within the African that we want. Isn't that what the AU says? The Africa we want. Ensuring that our laws take into consideration our lived realities. We are the ones who know what abortion looks like, the effects of abortion. Taking into lived realities, FGM, as I stand here today, 8 girls, I think 2 or 3 days, 10 girls, Nyokabi, about 3 days, or the day we were coming to Uganda, slept in a cell. These are girls who are barely 18 years, and they slept in a cell because they underwent FGM. Girls. Meanwhile, we have a government institution known as the Kenya Institution of Development of Curriculum in Kenya that has gone on ahead. And because we have been convinced by the white people that rape is occasioned by how we dress, this book that a lot of our children are going to go through this curriculum, the book has gone on ahead to affirm that how we dress as women, we are provoking men, and as such, the consequence is rape. Who is the true culprit in this matter? The adults who are sitting in the curriculum development institution, or the young girls who have had to undergo FGM, noting that children lack capacity to consent, meaning there is an adult behind it. And so it is time we must start truly interrogating the negative effect, the imbalance, the snatching of our narrative that colonialism is taking place. And it would be prudent to also name or mention that as we talk about colonialism, we also need to understand what is neo-colonialism and what that is doing to us. Because it is coming in a different form where they're saying, let's sit on the table together, but in reality, it is neo-colonialism just using new terms. The same way we know slavery ended 100 years ago, but now we have modern day slavery. And so this is a conversation that we must definitely come to talk about. Lastly, as I finish, I would want to mention the issue of public participation. In Kenya, as you know what is currently happening, strategic litigation and judicial activism has been very useful in Kenya, especially where the executive and the legislative body have failed us. And so we have managed to be able to access courts for strategic litigation on issues, and the most low-lying fruit has always been public participation. How did that happen? And that is why our Finance Act 2024-2025 was considered null and void or unconstitutional because it did not undergo any public participation. And so I stand before you urging you that in public participation, dignity, as Anad has mentioned several times, non-discrimination, equality before the law are very good grounds for being able to institute strategic litigation. And so for me, as I conclude, I want to say three things. And this is my call, that it is time we move away from the rhetorics. It is good to come here, to meet everyone, to be able to say truly, Haki, thank you for giving us the South-to-South conversation. This is truly what it should look like. And then we leave it at that. And so for me, I would want to urge that moving from the rhetorics, it is important that we continue with these conversations. It is important to educate our judges. It is important that lawyers continue, or judicial officers actually. And this can be done through amicus, interested parties, but even having forums like this where we have genuine conversation. Research is going to be very useful. And for me, research comes in two ways, where we need to look into explicit knowledge and tacit knowledge. How is that the two blended? How will procedures and guidelines and our day-to-day living be able to translate in documents that allow Africans to be Africans? I also want to talk about utilization of technology. If there is something we are learning from the protests that recently happened in Uganda and continue to happen in my country, is that tech is a very useful space, if used the right way. It can be the point where we inform people correctly on what is happening. It can be a point where we are able to seek for accountability, as well as utilization of resources. And lastly, for me, it's from what is currently happening in my country and what we are learning about the protests, is that if this has to succeed, civil society must stop the hierarchical process that we have. We must stop saying this organization has to be the big brother of others. So that has to end. Women rights organizations have to learn how to work in unity. We must also understand what self-organizing looks like, what a collective agency looks like. And lastly, let's continue to be resilient. Even when things don't work, let's be happy to go back to the drawing board and come back stronger and better. Like us Kenyans, next week, we are back. Thank you very much.
Thank you very much, Isabella, for firing us up and also for responding to the keynote. The time is now. I hope you're now warm enough. Are we hot? Are we boiling? Are we ready? Okay. So this being a Baraza, we're going to have some conversations here, and then others have to continue happening because we continue having the conversations. So as indicated earlier, we have our online participants, already some of these who are on listening to us live on X have sent their comments, which I'll read out. And then the Uganda Law Society that are in the Zoom, we have also chats that are there that I'll read out. And then here in the room, we'll give 4, 5, 6 responses and then can give back to the opening panel to wrap it up, and then we can break off the session. Is that fair enough? Okay. So, do we begin with the ones on X? Okay. We have a very, very heavily pregnant conversation on X Live. And there is a comment around clearing the abortion law to protect SRHR. At the moment, health professionals face legal risks when trying to save women's lives. As a parent of my primary 7 daughter, were to get pregnant and her health is at risk, I believe she should access an abortion. And then there's a whole conversation around including and introducing sex education, including safe sex practices among preventive methods that can protect the young ones. There's also a contestation around whether the pregnancy should be dangerous or not. And then another person is saying, but the pregnancy is not life-threatening. Must it be illegal? Then there's a recommendation around better sensitization, but abortion should not be allowed. And then there's a conversation around why are men not supporting abortion? And what is this madness I am seeing? The thing is in the body of women, but people responding are men. I think you're really idle. And that's a man. And then there's a conversation like there's many medical persons and citizens who constantly abuse the law in Uganda. Otherwise, it would be a useful law on abortion. Then there's a conversation around many people confuse cultural and religious principles with reality. Some will still debate about it, that abortion is not okay, ignoring cases and the causes like rape, defilement, that are the underlying causes. So we'll now get to the comments in the room as we are also harvesting the ones that are coming in from the Uganda Law Society, and then we can be able to respond to that as the opening panel. So over to you for us who have any comments, any responses here in the room as we are getting the ones that are coming in the chats in Zoom. Are we overwhelmed? Underwhelmed? Feel good? Okay.
They want a cup of coffee.
Or would like coffee and tea? But we can't break this panel. When we break the panel, we are breaking because as indicated after this panel, we are closing the meeting for the online audiences. So we must finish this business now. Do you have any comments in the room? Yes, can we begin there?
Thank you so much.
Give us your name. Your name and country, and then comment. And please, let's make our comments as brief as possible because there's many of us that would like to engage.
Okay, I'm Nimrod Musa from Uganda. And my question is to all the panelists. How do we wean ourselves off the problematic jurisprudence? Because there are several decisions in Kenya that relied on Roe v. Wade. With Roe v. Wade gone, how do we make sure that we create an indigenous jurisprudence that speaks to our realities? Thank you.
Thank you, Nimrod. Any other comment in the room? Yes, we have here.
Thank you so much. Kenneth Kapoza is my name. I want to applaud our panelists for the wonderful brief they have shared with us this morning. Thank you so much. It was enriching. I just want to add my voice to what Anand has presented, that we are doing our best to equally decriminalize the concept of abortion in Uganda. SEHAD has taken out a petition that seeks to challenge government's omission to enact a law that regulates the termination of pregnancy in Uganda. That petition is currently lying in the Constitutional Court of Uganda, and it is pending judgment, actually. So we are equally praying hard that indeed the Constitutional Court agrees with us that there is need to enact a law that regulates the termination of pregnancy in this country. So thank you so much. The efforts are on, and it's work in progress.
Thank you. We have a hand behind you there.
Thank you so much. My name is Leah Nasasra from the Female Lawyers Network, Uganda. My comment comes from the takeaway. I have many takeaways, but what stood out for me was how to use the law as a tool for liberation. And I'm thinking we can use this platform to influence policy reform. Given the social and governance barriers in Uganda, we have a few provisions around health reproductive rights scattered in different laws, and they are few in the first place. So for me, I think this can be a platform for a well-grounded study to influence policy reform in Uganda.
Thank you. Espanol, any comment from Latin America? Yes.
Thank you. Do you hear me? Yes. This is for the former special rapporteur and for Giovanna. You mentioned that the Christian influence, together with medical evidence, they came together and they are used for defending fetuses' rights. So I'm wondering if what in your experience has been more powerful to challenge that narrative, which sources of research, which arguments, because I have the intuition that the belief that it is not getting into that area and disputing in the medical area, but challenging the whole narrative with actually demonstrating that this is a creation and an argument developed with a colonial basis. So which arguments, which sources we can use, or in your experience, are more powerful and effective to challenge that strategy?
Thank you. Okay, I think that's it. We do not have any comments from Zoom. Yes, here.
Dorothy Amaranth from Uganda. I'd like to upload the speakers. I think you almost left us empty. We agreed we had nothing useful to almost add on. But I think for me, the question of bringing on the judges to create laws for the people, what we relate with, like bringing in that lived experience into law for it to be useful. Because most of the laws we have right now are not really useful. They are torturing, especially the women in this subject area. They are paid. I'm just making a comment generally and maybe trying to appeal to the judiciary, like members of the judiciary that attend these barazas, that beyond looking at the law as is plainly, we need them to embrace the approach of judicial activism, where they give us room to come and have meetings, sidebarring, I don't know if it's the right word, where we kind of have the space to say, these are the merits of the case, because sometimes when you're making submissions and all, you're detached from the reality. You don't have the human face and the aspect. So I'm saying like the peer-to-peer approach, like judge to judge, academicians, is there where we can now start approaching humanitarian cases, especially these cases that are, hard to prove? Sexual rights, reproductive rights, they're very contested issues. And there are lived realities. They're not going to stop today. We shall continue having sex. We shall continue having abortions. And the cycle will continue. And so what are we regulating? Are we regulating for paper? Are we regulating to kill? Because what is more important? Saving face for morality, like that moralistic face? Or like, who are you sacrificing in the end? Who are we actually trying to help? You know, while we are making judgments, who are we really trying to help? I think we need to paint a human face. Most times we fear the judges, we think, oh my God, they're demigods from somewhere else. But they also have sex, and I'm sure at a certain point, their girlfriends have sought these services. My Lord, the Lordship's in here, you'll forgive my expressions herein. But the point I'm trying to drive here is they're human like us, and it could happen to anybody, your wife, your child, any circumstance. So I think we need to be a bit proactive, but also welcoming. When the bar approaches the bench from a more of like, judicial activism, we're supposed to be friends of court. And so I think we need to step away from the procedural, the tough, and, like look at the merits of the case in a way that is going to help the bigger public. For me, that is just my plea. It's a general comment. I've used so many words, but I'm just saying let's be humane and have a human face to these cases. Thank you.
Thank you very much. We'd like to pull this to a close. If you have any comment, yes. The last one.
Thank you very much. My name is Frida Mutes. I come from Uganda. I'm a feminist human rights lawyer. My comment, in addition to what you have all said, that is very, very enriching, especially our keynote speaker. I just wanted to add the issue of intersectionality, looking at decolonization from an intersectional lens. And I am speaking about this because it's not just sexual and reproductive rights that are under attack or are imposed on us through the colonial lens. We have so many other battles. And for me, my appeal to this room is for us all to look at other causes that would liberate us from the colonial, the colonial imposition on us. And I want to share an example of what is happening, the current context that is happening in Kenya, where Isabella is coming from, and the right to demonstrate and how that is criminalized in our countries, where people are still being charged for being common nuisance. How are we looking at laws like those, and also thinking about joining such causes for a holistic decolonization agenda? I also wanted to add, probably on the issue of economic liberation. If we do not look at economic power of our continent, especially in the era of the attacks on the human rights mechanism, on the geopolitics that are happening, and how our continent is seen, I think even the powers that we have and the leverage that we have to use the human rights mechanism is going to be taken away, especially with the anti-gender, anti-rights groups that are very economically oiled, that are coming to our continent with bags of money and accounted for to come and push for the agenda. So I would also really want to urge us in the room to look at that. Thank you very much.
Thank you. The last comment is here, and then we wind up this session. Can't hear you.
Hello, can you hear me now? Good morning, can you hear me now?
Yeah.
Okay, my name is Jessica Oga. I am from Nigeria. I just wanted to give a comment on Anat's discussion on the colonial roots of abortions and how it strongly resonates with the Nigerian situation. Nigeria has one of the most restrictive abortions laws inherited from British colonial rule, with Section 228 providing that any person who intends to procure a miscarriage of a woman is guilty of a felony and is liable to imprisonment for 14 years. I think this exemplifies Grover's point about coloniality and surviving colonialism, as these laws we've seen continue to persist decades after independence. But what I would like to just highlight is that platforms like these provides us an opportunity to reflect as Nigerians and academicians on how we can push to reform our laws, as we've seen that this definitely reflects the broader struggle to decolonize legal system and achieve reproductive justice in Nigeria. Thank you.
Thank you very much for sharing experiences. So now I'll ask my panelists where they are to respond. Most of these actually are people that are actually agreeing with how you've tickled them. So we'll begin with Anand, and then we'll end with the...
Okay, I think they're very useful comments. I'll start with my friend from Nigeria. And I want to add a word of caution. Right now, this year itself, the Indian government started to replace the so-called criminal laws. We have the Indian Penal Code we had before June, the Criminal Procedure Code, and the Indian Evidence Act. Now, this government, to show that they are anti-colonial, they are nothing of the sort. They are right-wing religious group. They actually brought the new laws in the sense they actually had Sanskrit names, which ignores the south of India, which is a separate historical trajectory altogether. They've not really changed anything in terms of concepts, okay? Presumption of innocence, nothing changed. They have actually increased criminality. So are they decolonial? No. Colonization was criminalizing huge number of behaviors which were not criminalized earlier. Not at all. So like, what are the ill in earlier society? You know, all our societies were not great. Let's be honest. At least I can say for India. We had the caste system right from centuries ago. Then we had religious divisions. All those were bad things. Okay? But this government want to pretend there was what they call Ram Raja. Lord Ram, he has to be, oh my God, he has to be revered. So that's their thinking. So we don't want to go back to that. But, and we have to be clear about what we want in our society from the old days and what we don't. Camaraderie, helping each other, that is native culture, is good. That is preserved. But going back, we don't want to go back. Our constitution makers were very clear, and I think they were very wise people, men and women, who actually saw, and our constitution actually is one of the few which recognizes pluralism. We have a huge number of religious, ethnic communities, caste communities, and the challenge was after the division of India into Pakistan and India on religious grounds, how do you actually bring about a society which will be stable, which will be democratic, which will have freedom of expression, all those constitutional rights. And those constitutional rights are from the human rights. We are not bringing them on their own. Okay, there is some argument to suggest in the Ashoka Empire, actually equality was actually as a notion, very strong notion of equality in the Buddhist Ashoka Empire. So we bring those things, yeah, no problem. But now we have gone beyond that. We have laws to govern, which are administered by the state in terms of police, executive, and the judiciary. So we have a system which has constitution, lawmakers, it has executive which implements the laws, and which has judiciary which oversees the laws in the constitutional terms, striking it down, and then deciding how to implement them. Those didn't exist in those days. There was a sovereign who was the king. They decided whatever they wanted to do. We are first of all, democracy has come to us after a long time. So democracy is not not an Indian concept or an African concept. It's thought about, and it's not even a Western concept. Actually, the West had to come to that. Equality, liberté, fraternité was a revolution in 1789 in France. They were overthrowing their systems. So it's a universal system. But as I said, say for example, the human rights system which we actually want to bring about Equality was understood in the US differently. The 14th Amendment didn't treat white people or black people or Native Americans equally. The concept is there, but it applies unequally. We have to clearly understand that. So Martin Luther King understood that very well. He said, we are also entitled to equality. We are also entitled to study in the same school as the white people. And that's a historic struggle. Similarly, the Palestinians are saying, and the South African government has supported them in the International Court of Justice, they are entitled to their rights. You can't do what the Nazis did to the Jews that you are doing to the Palestinians. So there are these very important notions of human rights, equality, liberty, etc., which are unequally applied. They are unequally applied in international sphere, they are unequally applied in the national sphere. You know, if you go to court, if you're a Native American, you may not get justice because how the judges see it. Now the majority in the Dobbs case will see things differently. I think one of the major things is, though you have a constitution, do you see it as a transformative constitution? Do you see that the world should become from unequal to equal? Equal in real substantive terms between men and women, between marginalized communities. All communities should have a share in the pie. Are they educated? Are we going to do anything about people's education? People who are natives in our land, India, they have a special affirmative action. Despite that, they are not educated. What do we do? We have to see all that. The law can't get it. I think that's a very important thing that we must realize, that though you may have equality in the constitution, the delivery of that is very, very important. The other thing was 2 points I want to make, because I think my other colleagues have better to answer the other issues. Decolonization and intersectionality. I think my friend from Uganda said this. You know, you have to appreciate that we live in a capitalist society. Capitalist society means profits for certain sections of people. And it means raping of forests around the world. In Brazil, how the Amazonia has been destroyed is worth recording it and actually understanding it. They don't have any question of limiting their power. For them, the greed of money takes over. Now, and this is happening in India. The Adani group, the Ambani groups, they are actually taking over forests and industries are developing. It has huge impact on climate change. It has huge impact on the tribal communities in India who are actually dislodged from their habitats. Now, that is an other battle. Are you willing to fight that? What do you think of capitalism? We have to think about that. Is the profit motive the only way to survive? Now, you had an experience of Russian, it was never socialism, it was never communism. But what is the alternative to capitalism? That's a big issue, because capitalism means only certain sections of society actually benefit from it. In India, I can tell you, there are 1.4 billion. Only 0.4 billion have actually advanced and improved economically. The other 1 billion have not. We are rapidly growing. GDP is growing. Mr. Modi loves to say GDP, but inequality is increasing. So what the government is doing, give money to people. But money doesn't get dignity. If I don't have a job and I just get some money to just survive, it brings no dignity to me. So we have to think about economic issues which you talked about. How do we change a system which thrives on profit and exploitation to a system which is equitable, egalitarian? That's a big issue, because historically socialists and communists try to change it. And let me say, I am a leftist. I won't say communist and socialist because that doesn't mean much now. But how do we change it so that we literally have a better system economically and politically? Politically, I think the world has seen we have constitutionalism, which is an improvement of what is in the past. But in economic terms, the left, which I belong to, has failed. We need to have a new system. How do we actually arrive at a system which works? The Russians and the Chinese are the most capitalist societies today, which means that system that they wanted to plant on the world has failed. I'm just putting it very, very pithily, as it were. And the last point you made, judicial activism morality, I think you said. Yes. You know, we've had a lot of judicial activism in India from the 80s because we believe our constitution is transformative. The present Chief Justice has given a lot of speeches. But when you have judicial activism, then there's a problem on the other side. They can also become very right-wing. So you have a constitution in India which actually talks of liberty, equality, fraternity, and pluralism. See, all our societies, because of colonization, and even before colonization, there are peoples from other parts of the world who have come, settled, gone, whatever, and there are plurality of ethnic communities. Now, how do you deal with that if you are a democratic, constitutionally governed society? You have to have plurality, cultures, etc., without the same group exploiting, like in South Africa. The whites still dominate. The white people control the economy. There's no real, so their colonization is not only, or colonialism survives even economically. They're not replaced by black Africans in South Africa. So how do you change that without actually disrupting, without actually have communal killings? That is a challenge for people in South Africa. In Latin America, they just wiped out native communities. In Latin America, if you go to Mexico, there are hardly any original native people. They are in other countries. But without actually wiping out communities, how do you bring about a society through economic development which is egalitarian, which respects all communities, not only communities, genders, etc. That's the hugest challenge that we have today. We have the energy. Okay, I'm not as young as you, but I think I'm as young mentally in terms of mental energy. But that is the major challenge. How does, and Uganda had Idi Amin, my community was persecuted, but thank God things changed. It changed really for the better. And a lot of Asians even came back, but they're also capitalist, and they're not socialist or anything. So there are challenges that we have to face. How do we get over it? This is a space like Baraza and Haki have given where we can discuss this, and it's the social activists within civil society combined with the executive, the parliamentarians, judiciary, because the judicial activism is by judges who think that the constitution should be transformative. It's not a static thing. The word equality is not written in the 19th century. The whites are equal but not the blacks. So the US constitution was interpreted for a very long time. Equals can be treated equally, but not unequals can be treated equally. So black people would remain there. How do we change that? So that is what the transformative view of the constitution is all about. How judges and activists is based on that. So therefore there is need to actually discuss amongst civil society, parliamentarians, the judiciary, how we can move the society forward where we have a constitutional framework. Most countries have a good constitutional framework now, and it's improving all the time. But we don't have the economic blueprint to drive an equal society. The economic framework today is driving towards inequality. Let's be very clear about it. The people who are the have-nots in every country, whether it's the US, Britain, India, Uganda, they are becoming more and more impoverished in terms of the actual needs and desires today. So the real problem for politicians, for activists, for the judiciary is that where is the economic program? For a long time, the leftists and the communists thought that they had a program, but they don't. I'll be very frank about it. That's why the communist parties all over the world are withering away. We thought the state will wither away, but so this is the issue, and they are really to do with poverty of theory. But despite that, we can't give up our fight on abortion, on same-sex relations. Those are fights which we will wage on the basis of equality. We can't give up on that. We still have to develop other things, because that faces every nation. Thank you.
Thank you very much. So we'll give the two at least 1 to 2 minutes, and then we call this a wrap. Isabella?
All right. Thank you very much for the feedback. It truly demonstrates that you are attentive, you are listening, and you have been somewhat converted, and the fear is starting to go. But I will respond to two things. Nimrod, in terms of building up, because you categorically said the jurisprudence in Kenya, what we are doing, and we continue to do in court, is being able to remove ourselves from the Roe v. Wade as part of our jurisprudence. It's being able to affirm and utilize what is currently happening in Kenya to build up on what currently exists. Because to be honest, so far, courts have been kind to us. And so we are cognizant of that. And as such, we as lawyers, even when we go to present in court, we are doing our due diligence. We are making sure we are educating courts, we are informing courts of what is happening within the same situation to make sure that the jurisprudence continues to look more African and less what is outside there. When it comes to DCRIM, as rightly put, we need to continue centering it on the plight. What is this plight that victims are going through as opposed to the theory? And this supports in being able to remove the bias, the religious nuances, and it's also being able to situate it in terms of what it means for equality before the law and non-discrimination. But for this to happen, we must be very clear and concise on what we want. The message must be one. We must all speak the same language. In terms of Leah, what you spoke about strategic litigation, truly it is a very good tool for liberation. But unfortunately to date, strategic litigation is good for lawyers. It's good for our ego. But simply because we never disseminate this to the citizens. Do they know that we won and we won on these grounds? And unfortunately, media does not even do us justice. We see media only picks the most controversial issue and a statement in the judgment, but then does not go to truly say, in conclusion, this is what the court pronounced itself in. And so for me to say, it's good we are doing strategic litigation, it's good there is judicial activism, but do the citizens understand? So that would be my challenge. And in terms of judges, being able to put a human face, I'm throwing it back to everyone who goes to court, anyone who writes submissions. We have an obligation to situate this for them. Remember, for them, they are the end product. We are the ones who have interacted with our clients. We are the ones who are privy to all this information. And so for us, we need to read jurisprudence, especially for those who are similarly situated. Because it's there, and that's why today we're having the South to South. From the first day, we saw how we are all similarly situated in this fight. So we need to be able to do the same, similarly situate the situation, remove any level of bias, provide compelling scenarios. We often go to court and there is that gap. There is that gap of my client, but then we forget that this client, you might be in the same situation. And then lastly, even as we're in court, we must be able to present with a human face. We wear our power suits, that's fantastic, we look beautiful, but then if we do not have the human face, the judge will also not be able to pick on it. And then lastly for me is just to say that this is going to be a long journey. We might come out of here fired up, but let's not tire in the process. Thank you very much.
Thank you very much. Finally, Giovanna.
In 1 or 2 minutes, oh my God. So I'll tackle on the question of narrative, but I won't enter into the details, but I want to share two things that I think are very important in terms of narrative. One, that we need to focus more on narratives on hope. I think we spend a lot of time in describing human rights violation, and I think it's important. We need to continue doing so, but at the same time, we need to focus more energies on bringing hope and how we describe that and inspire people around hope, because our cause is also a cause for liberation and hope. And then the second piece that I want to say there is, I think it's important that we continue challenging the idea that it's just one definition or an homogeneous definition for justice. So at Women's Link, we talk about justice in plural, because we believe that the person who's at the center is the one who's defining what justice means for her or for them, right? And lastly, I'll tackle on the problem of jurisprudence. And I think here I am so aligned with my colleague Isabella, because I think it's so important that we democratize the law, and that in this idea of questioning ego, that we challenge the notion of, how strategic litigation is being defined. So we create rock stars lawyers, right? And I think it's important that we start questioning who's at the center of that cause. Who's at the center? Is it the lawyer? Is it the system? Or it's the person whose rights have been violated? We have to ask that question to ourselves every time that we're, taking on a case. And I think that's very important. And if we continue democratizing the law, and we understand that it doesn't belong to a certain people, right? To a certain group of people, because we need to connect how the law is being associated to privilege. And if we go back in history, who's been, the ones who initially allowed to study law? Who were the ones who were practicing the law? We need to bring that into our own, the work that we are doing. And I think the more we do so, and the more we center the people, we are going to create movements within our countries and our regions, and I think that's going to inspire more to bring support to our cases.
Thank you, Giovanna.
Yeah, I just wanted to actually come in the defense of judges, if I may. I'll tell you from real experience. I do a diverse kind of practice. I recently, I do a lot of work for people who are accused of drug use and drug trafficking and all. And I had 2 clients only last month. So the first case was transporting cannabis from one part of the state to the other. And if it's small quantity, you're out. But if it's so-called commercial quantity, then you're likely to be imprisoned. But then the question of bail is very important. And the burden is, unfortunately, in these narcotics, terrorists, etc. cases, there the burden on prima facie proving that you've not committed an offense is on the accused. So in one case, which was the first case I did last month, I got bail, and the judge said, Mr. Grover, have you got any criminal? My client, they always say, have you got criminal antecedents? So I said, none. So okay, bail granted. Same case, the first case was a person who was actually transporting cannabis from one state to the other. The second case was, he was not transporting, but he was the owner of the truck in which the cannabis was transported. So, but unfortunately, he has been alleged to have committed the same thing in 2-3 cases. So, the same questions came up. He said, Mr. Grover, same thing I'm asking you, any criminal antecedent? I said, yes, but if I'm the owner and all those people who are actually transporting, they blame it on me. Why am I being held responsible? So they said, no, sorry. Criminal antecedents out. Why I'm trying to say this is, when you say judges with a human face, this is very important. Very important. What do you mean by that? Unfortunately, if you go outside the rule, then you will not be in favor within the judicial community. So you have to be very clear that the idea of rules is to be objective and not discriminatory. So when you say judges with a human face, what do we understand? So way I understand, I address a lot of judicial academies, and way I understand is that under the Constitution, if you don't have the Constitution, then you will just be applying the rule. But when you have a Constitution, which, for example, take a case of bail. So now, until recently, because of the present government, they were just taking even chief ministers to jail because of so-called corruption. Okay, and they couldn't prove it, but bail was not being granted. So the Supreme Court came heavily down on the high courts or the state courts, saying, sorry, there is what is called liberty under the Constitution. When you have liberty under the Constitution, you can bring that human face. Under a statute, the law, you can't do it. You have to strictly or liberally interpret it, but you can't bring the human face in so easily. So when the Constitution says there's liberty, you cannot keep a person in behind bars for a long time being under trial. So there you can actually fashion tools to have a human face. Now this is where interpretation of the Constitution becomes very important. That's where, in the case of Dobbs, the majority, the conservative, okay, who say, no, the Constitution is written in black and white. We can't read into it, despite the fact they themselves have read into it so many times. 20 cases I can quote, That's why I said the judgment is dishonest. But I'm not on those judges because that is not relevant. You can actually, because constitutions are meant to be interpreted, they are broadly written. A person cannot be deprived of, I'm not saying his or her, their liberty without procedure established. It's a very broad thing. It can be interpreted. It can be interpreted regressively or progressively in a liberal manner. So that's where judges get the opportunity. Or in treaties, like the human rights treaties, or like the African Court, where it interprets things. So there is where the judges get. You can also do it in the statute, liberal interpretation, strict interpretation, but there's less room for maneuver. So when you say judges with a human face, you have to talk of the Constitution. The Constitution is meant to preserve a person's liberty, person's equality, non-discrimination. Those broad concepts are in the Constitution, not in statutory laws. Statutory laws only bring them down to earth, as it were, in specific cases. Like in HIV Act we have, it is the broadest consultation. Every person was consulted, and we have a fairly good act. But how to interpret it, you can also write, but that's not in favor amongst the parliamentarians. I think one of the things that Haki can do is also look at this issue. How, when you talk of liberal interpretation, how can you do it? How can you do it in the context of that particular court? How they have done it in the past? There are ways, like in England, Lord Denning had his own liberal way of interpreting. But I think that needs more discussion. But it's very important to make the point that the laws are not meant to oppress. The laws are meant to liberate people, except those colonial laws which are made to subordinate the indigenous populations. Do we need them in independent countries now? Do we need terrorist laws in independent India? Because you are making more terrorists with terrorist laws. Actually, in Kashmir, I can see there is so much terrorism now, even with a heavy hand, they're not able to bring. There has to be a political solution to that. You can't have a terrorist law to get rid of terrorism. Terrorism springs because of inequality, oppression. Like colonizers who are oppressing people. You can't say, now we'll remove the law and that'll be the end of it. You have to remove the colonizers. So I think we have to think about these things.
Thank you very much. So can we get a huge applause to our chief guest and the responders to the keynote address for challenging us. Like you see, the conversation cannot end, and it shouldn't end. Thank you very much, Anand. Thank you very much, Isabella.
Gracias.
Giovanna. And thank you very much, all of us, for really having made this a deeper discussion. Yes. So we are now going to break off for the break. And at this point, I'd like to take the opportunity to appreciate our online audience, because the online broadcast is going to end now. Thank you very much for joining us. Thank you very much for been part of the conversation. Thank you very much for spreading the conversation within your networks. And also, let's keep the conversation going. For us who are here in Entebbe, we're going to have a short tea break. And for the first time in my life, I'm going to be dictatorial because I'm a rights activist and a feminist. We are not going to have a long tea break because we need to manage your time. I'm asking your indulgence for us to have a 10-minute break and get our teas and get back, because at 11:45, we are starting the panel that is going to get deeper into these issues. And also, remember, we are running slightly late because of what happened yesterday, but you can